Welcome to Washington in Focus, your source for the week's top stories in the state of Washington. I'm Cole Lauterbach, managing editor for the Center Square Newswire service. This week, we'll be discussing California and Quebec taking steps to welcome Washington's carbon credit auction into the club, even though voters could abolish it in November. The state Supreme Court removing the bar entirely to become a lawyer in Washington. A new law giving unfettered digital access inside of the state's county election centers to a nonprofit with a controversial past, and the Western Washington city that's looking into requiring properties deconstruct homes instead of just knocking them down. That's ahead in Washington in Focus. I'm Cole Lauterbach.
Knowledge is power, and you deserve to know what happens in your state government. That's why the nonprofit Franklin News Foundation is bringing you straight news journalism through the Center Square, reporting on state authorities and publishing stories that show where your money goes and who spends it. By supporting the Center Square, you can track politicians' use of taxpayer money and demand transparency from elected officials. This is how we can equip everyday Americans to hold their government accountable. Become a supporter of Franklin today at franklinnews.org/donate.
Welcome back to Washington in Focus. I'm Cole Lauterbach. Now let's jump into the headlines. California and the Canadian province of Quebec say they're on board with Washington state linking its carbon credit auction to their established market. The process is complicated, but the Department of Ecology officials say the move is the right step. Joining me with more on this is Washington editor Brett Davis. Brett, why is the state pursuing linkage in the first place?
Well, essentially, it's because it's a cost containment tool to ensure the program continues to run smoothly. The thinking behind linkage is that it would create a more liquid market that could bring down clearing prices in Washington's carbon auctions, which have brought in more than $2 billion since they started last year. An October 2023 analysis by Ecology found that a larger linked market would result in more predictability when it comes to allowance prices and provide businesses with an incentive to increase investments in curbing their greenhouse gas emissions. The report also notes that a failure to link to a larger market might in fact doom the entire program.
Now, this is still really just preliminary steps, right? Before anything would even happen, if all goes right for the markets, they would be years, correct?
Correct. The plan must first clear regulatory hurdles in both the states and the Canadian province. The three jurisdictions are following their respective processes to explore, linking their various carbon markets. If the three jurisdictions enter into an agreement to link, linkage would then be attained through updates to regulations adopted by each jurisdiction. And this session, the Washington legislature, they passed a bill that would bring the state's fledgling carbon market regulations in sync with the joint California-Quebec market. But even with all that, the earliest the state could join the California-Quebec market would be 2025, and it might be several years after that. Just depends on how things go.
Right. In terms of, that the earliest 2025, but there's a bunch of different hangups that could take place that could see this push back even further, leaving Washington to continue kind of on its own autonomously. Right. In those debates that you mentioned when they were saying, this is what would have to happen before the state can link to the other two more established carbon auction markets, we saw some debate, and it came from an odd place. Progressives were standing up and voting against and speaking out against the thought of linking with California and Quebec. Can you explain what their motivation was?
That's right. In fact, it was Governor Jay Inslee's own 16-member Environmental Justice Council that sent a letter last October to the Department of Ecology saying combining Washington's market with California and Quebec, it could hurt communities where pollution causes the most harm and, weakens existing air quality improvement programs. So it's starting to look like Ecology may be finding itself caught between environmental groups that fear Washington's carbon market will become less green in order to become a part of a larger market. But meanwhile, linkage may be required to maintain the viability of Washington's carbon market. So it's, sort of caught between a rock and a hard place.
Yeah, with the requirement that Washington, like you said, roll back some of the provisions and become less green to actually meet California where they're at, which is saying something. What does that mean for gas prices?
Well, as noted earlier, a bigger market is expected to bring down carbon emission auction prices, which could lead to lower gas prices, or at least gas prices would go up less. I mean, they're probably still going to go up because of, carbon auctions, but they might go up less in this bigger, more liquid market.
And already you're seeing, I mean, the consensus was initially, well, by the people that were not pushing for it, that this was going to raise prices by around 50 cents a gallon. And they were right, from what we had seen, right? I mean, when it initially took place, you saw a 40 to 50 cent per gallon increase that put Washington at the highest price per gallon in the nation. So, you're looking at those prices and seeing that at that point, we did report on the thought that this could be too expensive to exist on its own. And I'm really surprised that we're not seeing progressives get in line with that, because they would rather see it there in its existing fashion, because those are the requirements that they passed in, the matter of green conservation. But at the same time, it would be better than nothing, which It sounds like this could just fall under the weight of its own, largesse in terms.
There has been some pushback from environmental groups that say this doesn't help the little guy, that this helps, big corporations. So there's that angle also.
Now, underlying all of this is the looming possibility that the carbon auction just goes away this fall, correct?
That's right. So on top of all that, a November ballot measure will ask, Washington voters if they want to repeal the state's fledgling carbon market. So I reached out to all three jurisdictions because they put out a statement saying, they were moving forward. And I asked them about Initiative 2117 to do away with the carbon market, because nothing was said in their statement, not surprisingly, about any of that. Sure. And Washington's Department of Ecology, they got back to me, and so did the California Air Resources Board. And they both said they're moving forward for now. And that's just all they're concentrating on right now. I didn't get a response from Quebec, but I imagine if I had, it would have been very polite and possibly in French.
You're right. Yes, Google Translate, do your job. Understood. We've covered, in California, we've covered CARB before, the Air Resources Board. And also what is notable is that they are one of the originating organizations that started the carbon-free vehicle by 2030 or 2035 initiative that a lot of states, progressive-leaning governed states, have adopted and said that they are going to jump on board with. And then the federal government has President Biden this week said he also is going to institute a rule that says no gas-powered vehicles by 2030. And it was the source of a lawsuit. Automakers sued California, saying that because your requirements often become the requirement of the entire country. Think of this material in this package is known by the state of California to cause cancer being on every label in the country. They sued and said that you are not able to govern the carbon requirements of the entire country based on what you feel is right. So it should be interesting to see just how far California, Washington, and Quebec go in doing this, especially because other states are looking at this thinking, should we adopt a carbon auction as well? I know we've reported on a couple other states that said that they were very interested in doing something similar. So November will definitely,
no pressure on Washington.
Absolutely. November will definitely be an interesting bellwether for the rest of the country, and give a thought to, hey, you might not want to do a carbon auction because, one, it'll raise gas prices, and two, your voters might revolt. So we will continue coverage.
It's a rock and a hard place.
Exactly. Yeah. Thank you, Brett. We'll keep an eye on this one. One of the most infamous professional licensing hurdles is the bar examination to become a lawyer. Washington State has decided to do away with the test. Capitol correspondent Carlene Johnson covered this announcement by the state's highest court. Carlene, where did they get this idea?
Well, we started hearing rumblings of this back in late 2020. I guess initially, new law school graduates, July 2020. So COVID, right? Didn't have to take the bar. Couldn't go do the in-person 2-day testing. And so they kind of just had them show their quality of work, present a portfolio, whatever, to prove that they were ready to be attorneys. And it was a go. And everybody went, oh, well, maybe the bar isn't so necessary. So at that point, the Washington State Supreme Court put a task force together called the Bar Licensure Task Force. And it's like 30 members, some of them, at least one of them, Supreme Court Justice herself, Raquel Montoya Lewis. She was co-chair of this task force. And then they had law school deans. They had people in private practice. They had folks representing Hispanic Attorneys Association. But what it came down to ultimately is it certainly seemed as if watching many of these task force meetings online that the agenda was set going in. It wasn't so much, would this be a good idea? It was, put your stamp on
this. It was a foregone conclusion they were trying to justify, really.
Yep.
Okay.
Yeah, it certainly went that way. And so came out as of last Friday in two separate rulings where state Supreme Court said, okay, lowering the bar by getting rid of the bar, if you will, different ways to prove you're competent, whether you go to law school or not, which is going to be the interesting takeaway here to prove that, you're competent to be an attorney in the state of Washington. And there was a huge influence here for DEI, diversity, equity, inclusion, basically saying, and Justice Montoya Lewis said some controversial remarks in one of the last meetings I watched. She said, well, attorneys or kids coming out of grad school, law school graduates, they might be able to get into grad school as a person of color, but they fail the bar exam in disproportionate numbers. Some people took issue with those comments. You're smart enough to get in and through, law school, for crying out loud, but then you don't test well if you're a person of color. Seemed to be a pretty sweeping generalization based on skin color. But that is apparently much of the motivation for this change.
So it was more of an equity thing behind it instead of just the thought that a good lawyer does not have to pass the bar to be a good lawyer, as compared to, you can't be a lawyer just because you didn't pass this test, even though you might be a fantastic lawyer. Now, Carlene, what was the reaction outside of the court system? Did you see anyone that had any hot takes on this?
Well, social media picked up on it, right away. There was a couple of guys on YouTube, sort of the dumbing down of society, if you want to simplify it in those terms. You've got the proponents of this saying, well, we need more attorneys, period. Whether you're going to be a corporate attorney, a divorce attorney, a, crash attorney, we need more of those. We need more attorneys of color to be representative of the clients that they're going to take on. And so this is just a way to get, more people interested in the profession.
Well, and I was curious about that when I read the story too. And, in an occupational licensing sense, to play devil's advocate, I wonder if this is a way to streamline the process also for out of state lawyers to practice in Washington, similar how to like a plumber licensed in Arizona. If he's licensed, they've got the same process. If there's what's this thing called reciprocity, could go to Washington state and not have to go through all of the costly hours of training all over again just to be able to make a living there. And, legal bills, I wonder if you supply and demand your way into a situation where they could become cheaper. If I need, say, somebody, a licensed attorney that has to defend my life if I'm being charged with murder, I would like to have that person pass the bar and be a highly functioning, attorney, similar to a brain surgeon. But if I don't necessarily know that I want to be able to, be required to pay brain surgeon rates in the courtroom, if I'm simply having somebody work through a legal tax filing that is a matter of, something a paralegal could do. I wonder if it's not just a scaling up and down in terms of expertise, because not all lawyers are created equal. They're like, doctors and nurses, right?
Well, exactly. And you pay the difference, right? I was doing some research for the story this week. And I mean, it runs Washington State as one of the higher, charges more here, for lawyers in Washington State, but it's about $288 on average, an hourly rate for an attorney. Now you can get, like you mentioned, you're somebody that's going to help you walk through setting up your, your family trust, right? That's not going to be a defense attorney for the quadruple murder, right? There's going to be, I know I went to extremes there, but, there's going to be quite a range, but most attorneys, in Washington State do operate on an hourly rate. So they're saying, okay, it's just take me roughly this number of hours. They give you that estimate up front. And then, then you are billed hourly. So you might be right in cases where you've got law students coming out and going, okay, I'm only going to be in these areas of practice and I won't have to charge as much because it's a supply and demand thing. If you've got more in the pipeline, then maybe those rates can come down. But one of the comments from the law school dean from Gonzaga, he raised some concerns and said, okay, I think we need to really slowly roll this out. His suggestion, which was not taken up ultimately, at least in what's been passed so far, is that the 5% of each incoming class of law school students can opt into, proving they're ready to go into practice in a different realm, right? Doing internships, doing 500 hours of work as a licensed legal intern to prove that they're competent. He's like, but let's make it really slow rollout. So 10 years from now, we can go, this helped, this hurt, this isn't working, or this is the best thing ever. And it's interesting too. I reached out to the Bar Association for comment, did not get anything back as yet, Cole, but I think that it's going to be, they're still going to be involved because they're the ones that are going to have to come up with some of what these new parameters are for proving, your final portfolio without the bar to show that you're ready to waive the bar and prove you're competent. They're going to come up with some of that criteria. So none of them are losing a job, if you will, but I did not get a comment back from the Bar Association.
Should be an interesting one to follow. Thank you, Carlene. In a story we've been following through the legislative process, Governor Jay Inslee signed legislation that puts some peculiar requirements on county election offices. Investigative reporter TJ Martinell joins us for a look into the elements of the new law. But first, TJ, what on earth is an Albert sensor?
So an Albert sensor is a type of intrusion detection system that monitors a specific system for malicious activities. They try and do hack into it, ransomware attacks, anything that threatens its cybersecurity.
And now those counties that have them, this is widespread. Counties all across the country have these. This little box, they really don't quite know what they're doing. They just kind of sit there and blink lights, right?
Yeah, it's literally a little black box that you have connected to your system, and it's outside the firewall.
And now this law is explain the new requirement as to what now has to happen in Washington State.
So all counties, technically they are not as written in the bill, they don't officially have to use Albert sensors, but as the bill is written and the way things are done, it is the only certified intrusion detection system that they are allowed to use. And I believe 36 of the 39 counties already have been using it. There were 3 holdouts, and the Secretary of State's office has been fighting very hard to try to get them to install these things, and they've been very reluctant to do so. In fact, they did at one point. In one case, Lincoln County had the Albert sensors when they were subject to a ransomware attack, and they were never notified by the Center for Internet Security, which manages the Albert sensors.
Now, Center for Internet Security, that's CIS. They made headlines for entirely different reasons back during the pandemic, right?
They were monitoring social media platforms on behalf of governments and contacting those platforms for posts to be removed. And specifically, not only in Washington State, but also in Arizona.
And you spoke to, I believe, Secretary of State Wyman, who was one of the ones that was kind of on that new frontier in a previous story. Tell us about how that conversation went.
Yeah, so what was interesting is this situation was where they had hired or had Secretary of State's office staff manually monitoring social media for posts that contained what they believed to be election disinformation or misinformation. They would then send it to an email address with the Center for Internet Security. Then CIS would contact the social media platform and then get back to the Secretary of State's office saying, yeah, this post has been removed or deleted. In one case, they flagged a tweet that was posted by the former state GOP chair, Susan Hutchinson, who was making comments about the 2004 governor election results.
But who was at the time the head of the state GOP. So that, in terms of asking something to be censored or, have their profile lowered, being a person that...
Yeah, it was flagged as being inflammatory.
Well, now that this law is indeed law and not just a bill, what's the timeline, TJ, for requiring all those boxes be in counties? Are we going to see them before November?
Well, with the 3 counties that haven't, the bill takes effect on June 6th. So they're going to have to comply at some point. And what's interesting about the bill is if the counties are not in compliance, the leadership, and by the way, the county commissioners decide whether or not this stuff is installed on the systems. Like they're the ones who enter into the contract. It's not the county auditors and it's not the IT staff with the county. They can be removed from office
if they don't.
And they're going to be a Class C felony.
Certainly more of a stick than a carrot. But we'll get reactions from the counties as this moves on, and we'll definitely make sure to report on how this turns out this summer. Thank you, TJ. Moving on, homes get demolished all the time. And in high value areas like the Puget Sound region, it's common for people to buy a property with the intent of leveling, let's say, an old house and building a new one that they prefer. The city of Tacoma is looking into an intriguing requirement that isn't demolition, rather something called deconstruction. I had never heard of this before until Seattle reporter Spencer Pauly reported on this. Spencer, would you explain the definition of deconstruction for us?
Sure. Well, I'm also unfamiliar with the term deconstruction up until this week when I cover the story. So, as a reporter, we're also crash course experts sometimes. So in the case of this, here I am. So deconstruction refers to the disassembling of a building with the intention of reusing the materials such as a roof, lumber, glass, appliances, etc. for future uses. I have to say that the deconstruction differs from salvaging. Salvaging is defined as the removal of valuable or useful surface level materials for use, while deconstruction is more of a systematic disassembly of the entire structure of a building for reuse. So I have to get technical there because that is what makes a difference from salvaging.
So now the city of Tacoma, are they all right? We're going to require this?
So as of now, no. What the Tacoma City Council did this week was approve a resolution that only directs the city manager to explore options for incentivizing deconstruction projects and material reuse. Along with that would be the estimated fiscal impacts that would go on to the city for establishing any kind of incentives for this. Now, they're exploring this while, many cities in Western Washington are kind of pinching pennies as a result of the COVID pandemic. And the reason Tacoma is looking at this is because this deconstruction aligns with, their climate action plans.
Well, and also, too, you said in the story what makes Tacoma, the area and Puget Sound in general, good for this deconstruction is that it's you've got a lot of old houses and that are made with old and old growth wood that is seen as valuable in terms of when people do salvage work and stuff like that. What would the process look in terms of cost and time for deconstruction compared to simple demolition?
Unfortunately, deconstruction is more expensive than just your regular demolition. Deconstruction sees costs ranging from $8 to $16 per square foot, whereas demolition can cost $4 to $10 per square foot. So it is more expensive to do this. Well, so we'll have to see what kind of incentives Tacoma provides so that, these property owners will say we can do this for sure instead of just, doing the cheaper option.
A subsidy almost becomes a requirement. Now, Spencer, is this done anywhere else? What about, hurdles to the more difficult process?
So when I did a little research, I did find that some cities do require deconstruction. For instance, here in the Puget Sound region, we have Portland requiring buildings built before 1940 to be deconstruction. There's also the city of Milwaukee, which recently, as back 2018, required all old homes to be deconstructed. But unfortunately, one hurdle that we're seeing is in the case of Milwaukee is that they had repeatedly suspended that rule because the city continued to fail finding any contractors who are able to do any kind of deconstruction. This is a new method of taking down a building, and there isn't a lot of experts doing this. So that is one glaring example where this might not be able to work.
Thank you, Spencer. Great story. And a big thank you to all of our journalists for sharing their stories. Stay up to date with all of these and more at thecentersquare.com. I'm Cole Lauterbach, and until next time, this has been Washington in Focus.